First of all, welcome. It's wonderful to see you all here. My name is Carl Arnold, and like I'm sure all of you, we are all overextended and over-affiliated. My first group was in CDOG, Chenango, Delaware, Otsego Gas Drilling Opposition Group. I'm also a member of NYH2O and Sierra Club and the Green Party. A brief overview of what's brought us here. A year ago, as far as I could see, this whole issue was still under the radar, even though hundreds of us around the state had been working for at least a year and a half, sometimes 2 years, to get the word out. And, but around that time, a couple of things happened. One member of CDOG wrote a draft ban bill. And I worked on it too, and then in April and May, I gave it to a number of state legislators who were very interested, one of whom, a state senator, had already come out several months before for a statewide ban. In May and June, everybody was anticipating the film Gasland, which of course was broadcast for a week on HBO. So that was one increment. And at the same time, the enthusiasm for a moratorium took hold, which led to several weeks of very intense lobbying in August for the Senate, and this remarkable result came out, 48-9 in favor of the moratorium. And that was bipartisan, it was upstate, downstate. These were very good signals, far more important, I think, than the moratorium itself. We also had some, and of course then the Assembly finally got around to it in November, and we know the rest. We also had some negative help from the Gulf of Mexico and most recently Fukushima. The two latest increments were the New York Times articles, which seemed to up the ante. And of course, in the last couple of days, we've seen the Howarth and Grafia Santoro article, which has already made a splash, as far as I've heard, around the world. We're here, of course, because everybody in this room wants a ban. We understand it deeply enough that that is the only thing that we can live with and that will allow us to live. Of course, the other thread in the movement is the regulatory approach. And as much as we may not like it, in my view anyway, those are our allies and they have to continue to be our allies, because ultimately what we're talking about when we talk about a ban is a piece of legislation in Albany. So those are the guys we have to deal with. Do people know who Tony Avella is, new state senator? So he introduced a ban bill. No co-sponsors, didn't know about any allies, but he took leadership. He did it. And now some people are signing on who wouldn't have the energy, let's say, to do it themselves. But people are starting to come around. And in the legislative session, if anybody's interested, I'll talk more about him and some other state legislators that we've met with. So, and also, by the way, there will be a companion bill in the Assembly, but we don't know who it is yet, but someone is seriously preparing that. Of course, at the same time, corporate pushback is increasing, no surprise. I don't know what's going on in the Southern Tier. Since the last couple of months I spent mostly in the city, but certainly there are constant TV ads on the regular channels, on cable, newspapers, magazines. Of course, showing how clean and wonderful gas is, the fuel of the future, and energy independence, and all the other myths that we know about. And probably as we speak, the deep pockets are trying to buy yet more politicians and judges. How many people here know what GSGI is? Just
You mean the
GSGI, a Global Shale Gas Initiative. A year ago, when Obama made yet another policy statement favoring gas, and I think specifically hydrofracking, the Department of State established an agency, the Global Shale Gas Initiative, and Google GSGI, you'll get it right away. It's an agency specifically to promote hydrofracking around the world, especially for China and India. So they're up and running. And as everybody here knows, most of the NGOs, including unfortunately still the Sierra Club, we're working on national, are still equivocating one way or another about a ban. They're not ready to come out for that yet, and that part of our job is to make them. So we don't have critical mass yet, but what we do have is momentum. And it's really, really clear, just in the last few months, how things have changed enormously. And I think we can all take tremendous encouragement from that. An example, people have heard about the Spectra pipeline, probably most everybody. For those who don't know, they want to put a pipeline from, I think it's the Millennium, I'm not sure, an extension under Jersey City, under the Hudson, into lower Manhattan. Remember the explosions recently in Pennsylvania, then there was San Bruno in California, and these things apparently are constant when you look at the detailed record. So that's what they want to do, and Mayor Bloomberg, of course, as we suspected for a couple of years, thinks he can get the gas and the clean water, and he doesn't get it, that he can only have one, not both. And we know a choice we want to pressure him to make. But he supported the Spectra pipeline. The point I'm getting at is that within days of finding this out, because of the momentum that we already have, a group of people got together, some are in this room, and immediately formed a new group to fight the pipeline. And they got organized so quickly and so smartly, and I think within a week or two, correct me Claire if I'm wrong, there was a website up, and people had found out that they could be interveners, and so the instructions were passed around, and it got done so quickly that I don't know how many were signed up as interveners, 500? 500 within what, 2 weeks, Heidi? And in the last couple of days, the Speaker of the New York City Council, Christine Quinn, signed as an intervener. The Manhattan Borough President, Scott Stringer, signed as an intervener, and I don't know who else did. And that was because of all the work that's been done in the last couple of years that enabled that group to form so quickly, understand the issue, and act. If you want to testify at the hearings, there was a time period in which you could register to do so, and the official term is to become an intervener. And whether or not you decide to testify, the fact that so many people signed as interveners was an initial signal to the federal FERC, Federal Energy Regulatory Commission. Thank you. I'm fairly good with acronyms, but I don't have all of them down yet. And so over 500 people signed, including some of those fairly well-known officials. So that was a terrific move. People probably know about the list, growing list of businesses and medical societies who are against fracking. And some of us are working on unions and churches, other civic groups. This is all part of the momentum that's building. Thank you. If anybody's interested, I've compiled what I'm sure is an incomplete list of bans and moratoriums, not just around the state. I think we've got 8 or 9 counties, a bunch of towns. We all know about Pittsburgh and Buffalo. And some people have been following what's going on in Australia. And by the way, the French government is supporting a bill to ban hydrofracking in France. Who'd have thunk? And a couple of months ago in Blackpool in the north of England, there was the first meeting of local people to resist the first frack there. I don't know if it's happened yet, Poland. It has a few months ago. Germany is scheduled. They're trying to do it all over the world, of course. Anyway, this 5-page incomplete list is available if anybody wants to see it. So a whole lot of people couldn't be here today. Just a couple of very quick quotes from Renee Fogelsang from Syracuse. Instead of being here today, she says, "I will not be attending the conference because I will be in New York City and then Washington, D.C. for Power Shift. We will be mobilizing thousands of students for a statewide and national ban on fracking. There are 900 students coming from New York State alone." Who we plan to plug into this movement. And is Lindsay Spear here? There's Lindsay, hi. So Lindsay knows more about this, and if anybody wants to know in the copious time of 30 seconds in between one thing and another, you can speak with her about it. And we got a beautiful 2-page report from Carol Roig and a couple of others in Sullivan County, and just a couple of lines from it, because it's very long, but just a couple of lines. "Activists are working to uncover potential conflicts of interest among our legislators and the unelected boards of various county-funded industrial development and economic development agencies that promoted tax breaks for the expansion of the Millennium Pipeline and actively promote gas drilling on their taxpayer-sponsored websites and publications." So people are doing all sorts of great things across the state. The world is looking at us. I would just like to close by saying this movement is about nothing less than survival, about preserving our lives, saving our butts, and making sure that the natural systems that sustain us all continue to do so. We're here today to up the ante and to focus more sharply on how to accomplish that. We need to build our momentum into critical mass. So let's get to work.
Good morning. My name's Mary Jo Long, and I don't know which program you have. I'm supposed to speak at two different topics, and so the one that I'm going to address first was the later topic in the early agenda. So I'm going to talk right now about what are lawyers for. And one of the reasons I guess I got nominated or talked into discussing this topic is, first of all, I am a lawyer for over 33 years. And I've also taught law, and when I was teaching law, I was training lawyers. I ran a clinical legal program at Case Western Reserve University Law School, taking law students in their last year of law school and actually taking them to court and having them draft legal documents and interview clients and that sort of stuff. And so it made me stand back a little bit and look at what the proper role of lawyers is. And even though I haven't been teaching law for a real long time now, that orientation stayed with me. I also, by the way, I live in Afton, New York, which is in Chenango County, a fairly small, rural, poor county that's near Binghamton. And 5 years ago, I was elected to the Afton Town Board. A year ago, I got reelected and have been very involved in a local road use law that I'm going to talk about in the later session. But this morning, I really want to talk about what is a good role that lawyers can play and how they can help. And I say that because sometimes in movements, and this one sometimes, I think there's a tendency or a desire to over-rely on attorneys to help you make the problem go away. And, it isn't limited to this movement. Over the years, as I've been involved in many issues, activists will come to me and say, well, can't you sue them? Doesn't the 14th Amendment prevent this? There's got to be some law, some magic formula that will solve this problem, to look to the law and attorneys and judges and courts as a way of solving the problem. And people don't like my answer, because the answer is there is no magic formula. Lawyers can help in many important ways, and I'm going to talk a little bit about that, but I have seen times when over-reliance on attorneys through a lawsuit to solve the problem result in a diffusion of energy, and activists and supporters spend more time raising money to pay the lawyers' fees than going out and organizing locally. And so it's important to know what is a good role for an attorney, and how to work with attorneys, and how to judge what attorneys say when they're involved, either for or against what you're trying to do. Obviously, lawyers can be helpful in many ways. They can, if your well water's polluted, you go to a lawyer to sue those who are responsible. Lawyers can help draft local legislation. They can represent towns if they've been sued, claiming that their legislation is overbroad or not legal. Lawyers will probably come to represent people who have been charged with vandalizing property or trespassing if they're on property trying to monitor some kind of gas drilling activity. There are all sorts of ways that lawyers will be useful. But we're tools. And I'm a gardener, so the tools I think of as, for some plants you need to dig up, you use a trowel. For a bigger plant, if it's a tree, you might need a backhoe. And so lawyers will help you like a trowel or a backhoe. They are a tool to help you accomplish the task. But it is the muscle of the activists and workers who are necessary to drive that tool in a direction that's helpful. And very seldom do lawsuits resolve the whole problem, although lawsuits are almost always involved in the process of dealing with the problem. The great problems of our society, such as slavery, the change, the abolition of slavery, the expansion of the vote to include former slaves and black people, to include women, all of those things didn't come through lawsuits. They came through the efforts of people changing public opinion, expanding the agenda of what seemed politically possible. And yet there are great lawsuits that have helped. Brown versus the Board of Education was a massive effort. The case that declared separate but equal schools was unconstitutional. That happened in 1954. It interpreted the 14th Amendment of the U.S. Constitution, which was passed in 1868. So it took, and the courts changed their interpretation to change the law by 1954. And no matter how brilliant the lawyers were, and they were, Thurgood Marshall and the NAACP Legal Defense Fund organized a strategy and a campaign about how to attack this problem of school segregation. And it went through many lawsuits and led to a very good result. But that lawsuit and the winning of that lawsuit in the Supreme Court didn't happen in isolation from the massive efforts of civil rights activists, their laborious work, sometimes violent confrontations, and that activist work is what what shifted public opinion and made the political space for the Supreme Court and judges to make that change. A lesson I have said, well, in fact, I will say. I was when I first became a lawyer, I was in New York City, and I took the New York bar exam in 1977. And 2 years later is when I moved to Cleveland, Ohio, and started teaching. And so in order to practice law in Ohio, I had to take the Ohio bar exam 2 years after the New York bar exam. And by the time I took the Ohio bar exam, and I would read some of the questions, and some of them were multiple choice and some essay, and I would look at the options and I would say, the correct answer is, it depends on what judge you have. That was not one of the options in the multiple choice, but having practiced law, I had learned, only 2 years at that point, I had learned that lesson. And you need to remember that. The law is what the judges say it is. And so right now, judges are comfortable upholding the current legal system, which ranks corporate privileges higher than community conditions, whether it's environmental threats, health impacts, or trying to develop sustainable economic activity. But courts are subject to public pressure, even if they're not elected. And they have shifted their interpretations, as I've discussed in terms of school segregation. And so lawyers who represent people will be helpful in helping in one of the channels of influencing the direction in which we're going to go toward a ban. I kind of made a list, and it's not in any particular order of importance, but I kind of wanted you to know, first of all, practical stuff. I talked about the historical, now the practical. First of all, keep in mind, when lawyers talk about gas drilling, there are more lawyers who work for the gas companies and the pro-gas drillers than lawyers who are helping and working with the people who are against hydrofracking. And I say gas drilling, I mean, there's some distinctions. I'm really kind of referring to the high volume horizontal hydraulic fracturing, which has not yet happened here in New York State. And that's in part because lawyers are, in law school, they're trained to be hired guns. The dominant ideology that lawyers are trained at in law school is to not ask what is the right outcome. Law students who ask that question in law school are ridiculed for caring about the outcome. They are trained to believe, and it is in their economic interest, of course, to do that, that they don't have to ask what's right, what's just. They have to zealously represent their client and believe that the judicial process and the legal process generates justice from that. And it doesn't take too many years of doing that to recognize that that isn't the case. Money talks louder and all that. But so when I've been in meetings where, one of the very first meetings on gas drilling that I went to 3 years ago, arrived a little late. It was more for municipal officials, and I was a town board member. And, they have the panel of experts at the front of the room, and one of them is a lawyer, and a supervisor in I think it was the town of Highland, said something about, well, we passed a moratorium. And the lawyer up at the front said, oh, you can't do that. And I hear that every once in a while from lawyers. And anytime you hear a lawyer say, oh, you can't do that, you have to question that immediately. That is not what a lawyer is supposed to say if the lawyer is on your side. That is what a lawyer says if they're on the other side. Lawyers are trained. You don't say, my client would rather that you not do that. They say, oh, you can't do that. And they will, and the lawyer's job, and it is our ethical obligation, to marshal as many arguments as you can for the side you're representing. And I will talk a little bit more about that in terms of the substantive arguments like regulatory takings and some things that are beginning to be said by lawyers and then repeated by other people. And those kinds of statements are aimed to discourage people from being activists because it's much easier on the lawyer and his or her client if you say, oh, I can't do that? Oh, okay. I guess I have to ask nicer or whatever it is. So that's one of the first ones I jotted down into sort of thinking about how to deal with lawyers. Another one is threatening to sue. It's easy to threaten to sue. I'm going to sue you. We're going to sue you. You're going to get sued. I've been told that in my town board because we're working on this road preservation law. Oh, you're going to get sued. It's going to cost so much money. On and on and on. Remember, either if it's the lawyer or somebody parroting the language and message of the lawyer, it's easy to claim to sue. It's a much harder thing to actually do it. It costs a lot of money, and lawyers don't usually do it for free. So take it with a grain of salt when they threaten to sue. And in general, my perspective is that the lawyer's role is to try to help the client accomplish the goal, not to define the goal. If someone, I'm going to take it out of the gas drilling context because I don't know how it will necessarily come out in there. But if there's some recently sit-down strikes in, what was that, Michigan or Illinois? A company was going bankrupt and they weren't paying their workers. They were owed wages for work they'd already done, and the company's saying, well, we don't have the money. And the workers actually just occupied the factory they worked in. They sat down. Now, if you asked a lawyer, the lawyer would say, well, that's illegal. You can't do that. All right? But a lawyer who's representing those workers would say, well, it's a violation of this law, and, if they arrest you, you get charged. Sort of tell you the consequences of your action, but not tell you that you can't do it. Because sometimes, I've been involved in movements where there's been civil disobedience. The civil rights movement in the South, in my child, I was a child watching television while children and adults were violating the law. They were sitting in segregated lunch counters where they weren't allowed. So sometimes you do things and you don't really want the lawyer just saying, oh no, you can't possibly do that because it's illegal. You want the lawyer to advise you of the consequences, but you have to decide what you're going to do. And so lawyers should be helping you create the best arguments they can for the side. The rights of nature may be the way we'll go eventually, as opposed to the rights of corporations. I hope so. And so lastly, in terms of how we deal with the pro-gas people, I think one of my most common sayings to clients, and sometimes to myself, is you never get anything if you don't ask. So, and really demand. You never want to negotiate with yourself. Don't say, I want a ban, but I can never get it, so I'm only going to ask for a moratorium for 5 years. Because when you reduce your demand, they're going to actually come back with something less than that. Oh, you only want a moratorium for 5 years? Well, we'll give you a moratorium for a year. You only want preventing gas drilling in New York City watershed. Okay, well, we'll give you, they'll always, you'll never get more than what you ask. They don't do it that way. So you have to be very clear about what you're demanding, and I've experienced it. I've had times when I, as the attorney for a client, I want to settle the case. I want to, have the bird in the hand versus the possibility of having a poorer outcome after trial or this or that. And I've learned that when my clients demand more, I end up getting them more. Because I can't settle a case, ethically, I can't settle a case. I can't give in without my client's permission. So, I'm telling you all, hang in there, okay? All right. I think if you will hold, in terms of questions, I think, oh, I do, okay. So if there's a question, go ahead.
John Cosma, Sustainable Otsego, Fly Creek, New York. I know nothing about the township you represent. The question I have is, why are they concentrating on road use laws rather than concentrating on banning heavy industry, of which gas operations is a part?
The quick answer is where we're at politically in our little town. And actually, the later presentation I'm going to make is going to be talking about some of those dynamics. We're greatly encouraged to see other towns making more radical demands.
That would be us.
Yes, which is you. And I think that, like Ben Price, who's going to be making the next presentation, will be talking about, I think he'll address that to some extent. And also, for us in little town of Afton, there are still quite a few people who see dollar signs in their future, and they hope that this is the economic salvation of their financial difficulties. And so it's taken some time for people to learn that even the ones who have enough land and have leased or want to lease may not be benefiting. And so we're still going through an education process in our little town. But it's a good question, and it's a part of a broader discussion, which I do want to have to talk more about, but maybe in the context of the powers of local government, which is something I'm going to talk about a little later. Okay? Yes.
Hi, David Baker, Walton, New York. Do we have to start focusing as a movement on the judiciary that's going to be deciding these cases down the road?
No, I mean, my opinion is we have to be focused on grassroots organizing. They will follow. I mean, judges in New York are elected, although they serve very long terms, and so there could be some long-term strategies about judges supporting judicial candidates, but they try to insulate judges from these issues, and I think it's easier to influence elected, like government officials, town boards, county boards, and all that. I mean, that's my gut sense.
My name is Ben Price. I'm with the Community Environmental Legal Defense Fund. My position with the Legal Defense Fund is Projects Director. I'm not an attorney. I get accused of being one in the newspapers constantly, and sometimes think about demanding a retraction. That doesn't mean that I don't like lawyers. I work with lawyers. The Legal Defense Fund is a public service law firm. We offer free legal services to communities and to local community groups. And the work that I'm involved in predominantly is to work with them in drafting local laws. And lately, the local laws are about banning fracking, banning this technique of gas extraction in their communities. Now, we haven't always worked on gas drilling. It just happens to be the huge issue that is confronting communities throughout Pennsylvania, which is where I'm based, also in New York, in Ohio, West Virginia, and Maryland, and as it turns out, I'm working in all of those places to one degree or another. So I get around. The title, I think, of my presentation, as the program states it, is that we don't have a fracking problem, we have a democracy problem. And that's a pretty good shorthand of really what my work is all about. We need to define the problem correctly before we can approach how to solve the problem. Because the Legal Defense Fund doesn't just work on gas drilling, we have familiarity with the fact that people are being deprived of fundamental rights. That's the problem. We don't advocate, when I go into a community, I don't walk in and say, you need to stop gas drilling, because that's not my position. I have a strong opinion about fracking, and I have a strong opinion that it should be banned everywhere, just to tell you the truth. But it's not my job to dictate to any given community what their opinion should be and what outcome they should be driving for. And the reason for that is because I really am committed, as the mission statement of the Legal Defense Fund says, just to paraphrase, in helping communities to establish the greatest degree of local control and self-government possible on issues with direct local impact. In other words, we really believe that the people directly affected by governing decisions should be the ones who make them. And when we're told that the people directly affected by governing decisions aren't allowed to make them, it's not a matter of jurisdiction. It's not a matter of state preemption. They're the kinds of words we hear. It's not Dillon's rule. It's a fundamental denial of the right of self-determination and self-government in the place where you live. That's what it is. It's a denial of consent of the governed, which, when we read documents like the Declaration of Independence, that's the definition of injustice. When the people directly affected by government and governing decisions are denied the decision-making authority, either directly or through their representatives, and when their will is disregarded and consent of the governed is put aside, that's the definition of injustice and oppression. We don't like to talk about government in the United States, in our states, or at the local level, and characterize it as unjust, but it certainly has been. In the past, we have that experience. Thank Mary Jo for pointing out the historic context, that when the U.S. Constitution was adopted, it legalized ownership of one class of human being by another. It legalized it. It didn't just say whatever, it said it's perfectly legal. I've worked with communities on issues that have imposed the will of large agribusiness corporations on rural communities in Pennsylvania. Factory farms, land application of sewage sludge, things like that. Prior to the gas extraction issue, that was really one of the biggest issues that I heard from communities about in Pennsylvania. And the problem was that those industries had hired their attorneys to draft model legislation, lateraled that off to their lobbyists who took it into the legislature, into committee, looked up the legislator that they had assisted with getting elected, asked them to introduce the legislation, and got it passed. And what was the result? Preemption of local control of anything that had just been redefined in the legislature as a normal agricultural activity, like sludge application and factory farms. And that's how it works. We have laws in Pennsylvania, they have laws in Ohio, you have laws in New York that say municipalities may not regulate the gas extraction industry. It's none of your business. The state will decide, we'll regulate that. And by the way, the regulations that we'll use, that we'll enforce, in many cases were drafted by the regulated industry's attorneys. And so when those regulations become law, who governs? Who governs you where you live? It's the corporations, using your government as their convenient tool to get the outcomes that they want. We're being denied the fundamental right to self-govern in our communities. We don't have a fracking problem because actually, frankly, if we had the right recognize we have the right, but if we had the recognized authority to simply decide as communities that exposing ourselves and our kids to hydrofracturing was offered too great a risk, offered a risk that we weren't willing to take as community majorities. And if we were recognized to have the authority to act on that judgment as self-governing people, we wouldn't have a fracking problem. And the reason we wouldn't have a fracking problem is because we wouldn't have a democracy problem. We would be able to make that determination ourselves. But local self-government is denied. I'd just like to suggest that if you don't have the authority to make decisions on issues of direct local impact in the community where you live, you don't have self-government anywhere. Point to me on a map of New York State where you have the right to self-govern if you don't have that right where you live. Please find a place on the map and show it to me where you have that authority and that right. And if you can't find a spot, then it's a fundamental denial of the right. Because self-government, to be real, has to happen somewhere in some real place at some real time. And if it doesn't, then it's just an idea, it's a concept, it's not reality. And if you're being denied that authority, then what are you going to do about it? That's the question. And you really do have some options, and I'm not here to judge. I have my strong personal opinion about what we should do. One option is to do nothing and get fracked in this context. And if that's the decision of the community, that's their self-governing decision. But you know, we're the adults in the room, and when we decide to do nothing, we are responsible for the outcome. And if the outcome is the destruction of our communities, of our drinking water, of our environment, of our property values, of our quality of life, we're responsible for those outcomes if that's the decision we make. The second option, and we're going to talk about this a little bit more later, is to try to use the existing structure of law, the regulatory laws that are on the books. Try to get them to work for you. As we'll talk about in greater depth later, you can choose to do that, and I would predict the outcome would be you'll get fracked. Because the laws weren't written by the state legislature at the behest of the regulated industry to allow you to protect yourself against their profit-making and their resource extraction and their resource colonization of your communities. They weren't written so that that could be a real outcome. They're written to create the illusion that you have a democratic process and that you have some potential remedy for the harms that are threatening your community. We'll talk more at length about that a little bit later. The third option is you might actually, as a self-governing people who recognize your rights and don't surrender them without a fight, you might pass law, because that's what self-governing people do through their governments, that assert your rights and then put in place prohibitions on activities that would violate those rights. That's precisely what the community in Clarion County, Licking Township, did this past October when they adopted a community rights ordinance that we helped them draft that established a local Bill of Rights, including the right to water. By the way, that's actually mentioned in Article 1, Section 27 of Pennsylvania's state constitution as a fundamental right. Our courts, those judges, who you should not believe, and you shouldn't really care. And the first thing everybody asks is, hey, have your ordinances been upheld in court? My answer is, I don't remember appointing the court's king. The people make the decisions about what's valid law. The courts, I mean, yeah, we have a real tradition of them stepping in and changing law, amending the Constitution, amending amendments to the Constitution. But we don't start there. We assert our rights and we say, yes, we believe in them. We're not going to surrender them by saying we can't do anything about it. As soon as you say we're not going to do anything because we know that we're not going to win, you've surrendered. You might, or others might think that that's a valid or a rational decision to make. But it is surrender, and we should come to terms with it. When we say we're going to regulate the rate of destruction rather than ban it, we're saying we admit we don't have the authority to ban it. We admit we don't actually have the authority as self-governing communities to say no to things that we, in our best judgment, determine pose too great a threat to our communities to allow. When we're told, well, we can regulate it, we can zone it. We can say over here you can do the destruction, but not over here. They're terms of surrender. They're not actually self-assertion of rights. Slowing down the rate of destruction for some folks is easier because it seems legal. Because what we're told is, you can do that, but you can't assert your rights, as Joanne mentioned. You don't start from what you can't do. You start from what is it you want to accomplish. You don't start from what's the best deal we can get. You start from what is it we demand, and we're not going to surrender. And frankly, there's not an organization in the state or in the country. There's not an elected body in your community or at the state or federal level that has the authority to negotiate away even the smallest modicum of anyone else's rights. It's that simple. And that might seem harsh because there are folks who are trying to do the best they can given what they've got, given the tools. And we are afraid to get sued. Yep, we sure are. The attorneys for our municipalities advise our local officials. Let's talk about the attorney for the local municipalities for a minute. Now, no, I'm not being, I mean this sincerely. I think that they do their jobs as they're supposed to do them, as they have an obligation to do them. But we don't understand when we organize in our communities what that job is. And the question is, if they're doing a really good job, who are they doing it for? And the answer is, and this is what we have to get clear on, their job is not to represent the rights and the interests of the members and the residents of the community. That's not their job. As a matter of fact, they would not be serving their client correctly if that's what they did. Their client is the municipal corporation that hires them. And sometimes the interests of the municipal corporation, the municipality, differ from the rights and the interests of the residents of the municipality. And when that happens, the advice that your elected officials get sounds like this. Well, no, you can't pass a ban because the state says you can't. You can't regulate that industry at the local level. And so, checking the state law books, the attorney says to your elected folks, it tells me, no, you can't do what your folks are asking you to do. And then you go to your municipal meeting and you say, well, what you hear? Can you do it? And what you hear back is, geez, we sure wish we could help, but our hands are tied. We can't do it. The problem there is they're getting one particular bit of legal analysis that is all based on protecting the financial interest of the municipality. By the way, that's your tax money, just in case you didn't realize it. But they're not hearing information about how to protect the rights and the interests and to make sure that your fundamental rights to self-govern, to clean water and clean air, to not have your property values destroyed, to not have your quality of life ruined, to not make your community unsustainable. All of those things are not on the table unless you and your communities make the point and let the folks that you elected understand and educate them on this really fundamental point, and that is this. When you took your oath of office, you didn't swear to protect the financial interests of the municipality. You swore to protect the health, safety, and welfare of the community. At least that's the wording we have in Pennsylvania. Your folks probably have something along those lines here. And if they only take the advice of the municipal attorney representing the interests of the municipal corporation, then your rights are orphaned. You have no representative government because your interest and your will is not being considered by the elected officials. And you are being denied the fundamental right to a Republican form of government, guaranteed, by the way, by the U.S. Constitution. And if you're willing to settle for that and walk away and say, well, we tried, we did our best. I guess what we're going to have to do is we're going to try and zone it as best we can. We're going to try and regulate it as best we can because that's all we can do. It's the best deal we can get. You're leaving your rights behind. You surrender your rights. And what we're talking about in terms of adopting community rights ordinances is to assert your human and civil rights everywhere, including at the local level, and not surrender them. And if you're going to lose them, because I just want to be as honest as I can be about all of this, we're not guaranteeing that if you follow in the footsteps of Pittsburgh, who we consulted with the city council there, we drafted their ordinance, and it has a Bill of Rights in it. I know the newspapers report it's simply a ban on drilling. It is a community rights ordinance. It has a local Bill of Rights, and it prohibits gas drilling within the city as a protection of those rights. It's in that context that there's a prohibition on gas drilling in Pittsburgh. It's not simply a freestanding prohibition. All right? It is in that context. If you take that strategy, there's no guarantee, folks in Pittsburgh, no guarantee that the industry might not sue and attempt to overturn their ordinance. What's the difference between doing it this way and trying to admit that you don't have the right to simply ban it and try to zone it or regulate it? What's the difference? In the first case, in the case of actually asserting your rights, you do not surrender them up front. If they're going to strip them from you, you make them come and do it publicly. You make them do it out in the open where everybody can see that that's what they're doing, because this isn't just a legal strategy, it's an organizing strategy. This is about exposing what the real nature of the problem is. And the real nature of the problem is we don't have a fracking problem, we have a democracy problem. We're being denied fundamental rights. And what are we going to do about it? In the end, what are we going to do about it? I'm not sure about my time, but okay. There are a few real obstacles to accomplishing what I'm talking about, and I don't minimize them, and we're not naive. One of the big obstacles is the regulatory fallacy, which again we'll talk about a little bit later. And that is the thought that using existing law, we can actually get the outcome we need, which is protecting our health, safety, and welfare, our quality of life, our natural environment, all of the rights that we know are ours. That's something we have to overcome, and I don't say this critically of the folks who continue to try to make those laws work for them. I think their hearts are in the right place. I think their strategy isn't. What's the second big obstacle? Well, it's called preemption, or sometimes Dillon's rule. The idea that a municipality, a local government, only has the authority that the state devolves to it. That the people living within all of our municipalities can only use their local governments in the ways that the state legislature specifically tells them they're allowed to. I know there are variances on this. You have a home rule provisions in the New York Constitution. Home rule still does not get you out completely from under the theory of Dillon's rule and preemption. The theory of statutory municipalities, which most Pennsylvania municipalities are, so are they in Ohio, West Virginia, Maryland. is that a municipality may only engage in those activities and pass those types of laws that the legislature specifically allows them to do. Under home rule, the theory is that a municipality may adopt any law locally so long as it doesn't conflict with the state constitution and so long as it doesn't conflict with a general law of the state. In other words, so long as the state doesn't specifically forbid you from doing it. Unfortunately, the difference between the two narrows over time, as it has in Pennsylvania. Home rule is possible in municipalities in Pennsylvania since 1972. In 1972, when that became constitutionally possible, the same year that they adopted the municipality's planning code that stripped home rule communities of the authority to make decisions on land use. In other words, sometimes we think we have something when it really has been limited quite a bit, and it's not much of a tool. So preemption, and the claim, for instance, that the municipal attorney will make to your elected officials that says, we can't pass this ban because the state says no. That's the preemption. The assumption is that the state's regulatory laws are actually higher law than your rights, and that we would question. The presumption is that you can't adopt local laws to assert and preserve your rights when the state engages in activities that strips them. That's simply an absurdity. The third big obstacle we have to overcome, and I want to come back to that. Let me finish that up for a second here. It is an absurdity that the state purports to have the authority to issue permits to large drilling corporations, that empowers state-chartered corporations, chartered in the name of the people of the state, that empowers those corporations to come into your municipality and engage in activities that violate your rights. It's an absurdity for the state, for attorneys, for the courts, to take the position that says, through preemption, through state laws, we can say you may not protect yourselves when we license a corporation to violate your rights. It's absolutely absurd. And it will stand so long as it's not challenged. And the community rights ordinance that we work with communities to adopt challenges that. It challenges the notion that regulation will protect us, and it challenges the notion that the state has authority to preempt us from protecting and asserting our rights and then empower corporations to violate them. And the third big obstacle that we have to overcome is the idea of corporate supremacy. The idea that corporations can be granted by courts privileges equivalent to living human beings, protections under the Bill of Rights, the ability to use preemptive law against whole communities, and the idea that a corporation's attorneys can threaten to sue a community for violating the rights, the constitutional rights of the corporation when we dare to govern them. I know that that's long-standing law, the idea of, some people call it corporate personhood. It's actually been, well, it was long-standing law up until 1886 that corporations were absolutely subordinate to the community. And so what happened to that long-standing law? What happened to that precedent? It was overturned. It was overturned without even so much as explaining why. Of course, when you're in charge, you don't have to explain why. And the courts were in charge. What are we going to do about it? Well, in the ordinances that we draft for communities, and that includes Pittsburgh's, it includes Licking Townships, it includes Mountain Lake Park in Garrett County, Maryland. About 4 weeks ago, they adopted an ordinance modeled on Pittsburgh's. In these ordinances, is a provision that says corporations that would violate the prohibitions of this ordinance will not be recognized to have the constitutional protections claimed by the courts and will not have recourse to the Commerce Clause, the Contracts Clause. Why? Because we're going to make them argue in court not only that we don't have the rights that we've enumerated in these ordinances, but that they do have the rights that the courts have given them. This is about changing the discussion. We don't want to, if there's going to be a legal challenge, we don't want to have a challenge that asks how many parts per million of toxin X are healthy for us to drink in our water. That's not the argument that we want to have between the expert witnesses. We don't want to have an argument about jurisdiction and whether or not the state can tell us to sit down and shut up. Of course, we'll have that argument, but we need to focus it on rights, and that's why rights are specifically, explicitly enumerated in the ordinances. To leave them out leaves us without that argument. By the way, included in the local bills of rights, including in Pittsburgh's and all the other communities that have passed and are considering passing it, is the recognition of the rights of nature. Pittsburgh was not the first city, was the first city in the United States to recognize inalienable rights of nature. It's not the first community. That was Tamaqua Borough in 2006, Schuylkill County, Pennsylvania. You may know that Ecuador adopted a constitution in 2008 by popular vote that also included that language. And in case you think that starting out from the municipal level is kind of like, wow, that's got to be labor intensive. Why would you start there? Why would you? And we're going to talk about that a little bit later today, I understand. But if you don't think that it'll have an effect, consider that the first nation on earth to recognize rights of nature borrowed the language for their constitution from a little law banning the land application of sewage sludge in Tamaqua Borough, Pennsylvania, that recognized the rights of nature. And the language from that little ordinance is in Ecuador's constitution. And it's now in Pittsburgh's ordinance. And it is in, I think it's probably about 20, 25 communities now have done so as well. And that includes in Pennsylvania, Maryland, New Hampshire, Virginia, and Maine. And we expect. I'm going to finish up here quickly. Probably not time for Q&A then, I guess. Well, okay. Well, thank you very much. I will just say we're going to be talking more about all of these things a little bit later on.
Rachel is a longstanding member of the Green Party. She ran for elective office for Attorney General, I believe, at least once. And did you get over 100,000 votes in the state? No. Okay. Okay. 65,000. Also, she was recently elected New York State Chapter Chair of the Sierra Club. So, Rachel Treichler.
And I'm also an attorney from Hammondsport near Keuka Lake in the Finger Lakes, and an activist with much of my time, as Carl said. So many of us are involved in the gas drilling issue and very concerned about the gas drilling because we're concerned about water. And there is now in the New York legislature a bill, two bills, one in the Senate, one in the Assembly, that address fundamental water issues that I think that gas drilling activists haven't been that aware of. So what I want to do with my time is talk about this legislation and give you a little bit of background on the water laws that we have now, which are not that well understood, and explain to you why I think that we're better protected with the existing law that we have than that this proposed legislation is actually to benefit gas drilling companies and other very large water withdrawers that want to take water out of New York and out of the Great Lakes Basin. So let me explain that. I do have a PowerPoint to help illustrate this, and I want to ask Jack Austin from the Coalition to Protect New York to come up here after I've given sort of some background on water law to help discuss the bill, because the Coalition to Protect New York has taken a very great public position asking questions about this legislation. I've handed out two handouts, and I think Jack is handing out another one. The CPNY press release with wonderful quotes from Sandra Steingraber. She's enunciating many of the ideas that Ben and Seldev have enunciated. Who's making the decisions about water? And also a memo of some of the concerns that we'll discuss with the PowerPoint. So Ben has talked to us about fundamental rights, and I think one of the most fundamental rights we have is the right to water, because water is essential to life. Without water, nothing on earth would have life. So the rights that we have to water are critical, and they are rights that have been recognized for thousands, if not tens of thousands of years. I've just briefly mentioned the water withdrawal bills that are currently in front of the New York legislature. This legislation is being promoted by some of the large environmental groups as environmentally friendly legislation. That's how it's been presented to our legislators. It is moving quickly through both the House and the Assembly, the Senate and the Assembly. It is now on the floor of both of those bodies, and may be voted on as soon as they come back into session on May the 2nd. We understand that the Senate is expected to vote on the bill on May 2nd, which is also the Earth Day Lobby Day. The Assembly may be listening to some of the concerns that have been raised. There's a rumor that the Assembly is considering some amendments to address some of our concerns, so we really urge everyone to contact your representatives, particularly your Assembly members, and raise these issues with them. As we've said, the strong public interest in water has been recognized for generations. We have water withdrawal rights in New York. The statute, they're imposed by statute in the environmental conservation law, and they are also established by common law principles established by judicial decisions. The case law thread establishing water law principles, riparian rights principles, come from the English common law, come forward into colonial law and into the law of our state, and originate actually with Roman law. Under current statutory rules, permits are required for public water supplies and for certain other uses such as agricultural irrigation, but mainly for public water supplies. In addition, we have new legislation enacted in 2009 that requires the reporting and registration of surface and groundwater withdrawals exceeding 100,000 gallons per day. But the main laws that we have governing rights to water in New York are the riparian rights established by case law. And the riparian rights in New York are similar to the laws of the eastern states in the United States, including the laws of Pennsylvania, are fairly similar to New York. And basically these rights are rights that are inherent in the ownership of land adjoining a water source. Each adjoining landowner has an equal and correlative right to make reasonable use of the water on the land that adjoins a stream. A riparian right is a right of use. You don't own the water. The water is held for the public. The public owns the water, but the adjoining landowners have a right to use the water, but that right is subject to the rights of all the other users as well. That is called a correlative right, when the various rights are intertwined and dependent on each other. And this is quite a different system than the system in the western United States, which is a prior appropriation system, which gives what are sometimes called hard rights to water. You own a right to take the water. This right can be transferred to other users. It can be transferred away from the land. The riparian rights are rights that go with the land, and they cannot be transferred away from the watershed. Some of this I've already said. I'll skip down to the next to the last point. Reasonableness. In determining what is a reasonable use, a use only becomes, reasonableness is contextual, and it only becomes unreasonable when another user is substantially injured. For this reason, riparian rights are difficult to predict in advance, because it is difficult to predict whether a use will be classified as reasonable or unreasonable. And this is one reason that industry, including the gas industry, don't really like riparian rights, because they make it difficult to plan and to be able to count on that you have a right for water, for very large amounts of water, in for long-term planning, for business planning. So riparian rights do present a problem for large water, potential problems for large water users, particularly if there are projected, if there's going to be less water, not enough water for all the users, and the various users will have to diminish their use. There are uncertainties, long-term uncertainties with riparian rights. And because of the desire, I think it's a desire of large water users to have more certain rights, there's been a push in a number of eastern states to establish permitting systems. These are not as strong of a rights as they have in the western states with prior appropriation systems, but they are permits that are granted by the state regulatory agencies. They're for a certain time period, and they're for a certain amount. And that's essentially what this new New York legislation is seeking to put in place, is a system of permits. The DEC will be authorized to issue permits for up to 10 years for certain amounts. And this is for any water withdrawal in the state. And there's no restriction, once you have a permit, there's no restriction on where you can take the water or what use that you will put the water to. So just to review this, the concept that under riparian rights you don't own the water, that the water belongs to the people. This is a concept that comes from Roman law, from the Institutes of Justinian. In 529 AD, there's a powerful statement here. By the law of nature, these things are common to mankind: the air, running water, the sea, and consequently the shores of the sea. No one, therefore, is forbidden to approach the seashore, provided that he respects habitations, monuments, and buildings which are not, like the sea, subject only to the law of nations. And this doctrine, this statement in the Institutes of Justinian is the basis for the modern public trust doctrine. And it traces, in the United States, it traces its origin through the Magna Carta, because it is this doctrine from the Institutes of Justinian that was followed when King John was forced to relinquish private fishing rights that he had granted to certain noblemen. And the idea was that the crown only held those resources for the benefit of all the people, and that they could not grant private rights to certain individuals. This concept was recognized in the United States in the 1842 Supreme Court case that addressed a New Jersey landowner who tried to exclude others from taking oysters from the mudflats on the river. And he claimed that he had title to the river, and the court held that the Magna Carta had settled the question of who owns fish and wildlife, and that the king did not have authority to give away dominion and property of lands in colonial America. And the court further ruled that since the American Revolution, the people held public trust responsibilities for fish and wildlife, except for the rights specified in the U.S. Constitution. Then, in 1892, the U.S. Supreme Court held that a state cannot divest itself of its public trust interest. And this was a case in which the Illinois legislature had granted the entire waterfront of Chicago to the Illinois Central Railroad. They actually thought better of it before this decision, so this decision was to some extent helping them not carry through with that. But the court said that they could not do that, that the lands were held in trust by the state for the people of the state, and that the state could not convey this land because the effect would be to destroy the public's right of navigation and fishing. The public trust doctrine has been recognized in New York. In a 1998 case in Suffolk County, the court said the common law did speak on this subject of environmental regulation. And in enacting environmental mandates, we are merely discharging our obligation to those who are dead and those who are living and those who are yet to be born. And talks about the public trust doctrine as the basis for that. So I've explained a distinction between Eastern water law and riparian rights and the Western states which have a prior appropriation system. It's interesting to see the map of the United States, to see these legal systems. The riparian rights states are here in the east. There are hybrid systems, which are the pale blue systems, and then in the white states are the ones with very hard prior appropriation systems. And to compare this map of the legal structure to the map of the rainfall precipitation in the United States. So you can see that the areas which have very low precipitation are the areas with the permitting systems. And I'll skip over the details of the prior appropriation rights. I think that people probably understand generally, but some of the aspects of that is the oldest rights have precedence. The rights can be transferred away from the land. And they can be abandoned, whereas riparian rights cannot be abandoned. Riparian rights refer to the rights of the surface waters. The common law had different rights for groundwater because it wasn't understood exactly how groundwater operated. We now know that groundwater and surface water are very connected. But a very important case in New York addressing groundwater rights is the 1900 case of Forbell against the city of New York. And in this case, it was held by the highest court in New York, the Court of Appeals, that the city of New York could not take millions of gallons of water a day from land that they owned in Brooklyn to the detriment of a farmer in Brooklyn. The city had 2 acres. They were pumping 3 to 10 million gallons a day. And the city said that is not within the riparian rights that the city has for those 2 acres. You're pumping this for use elsewhere. You are harming the other riparian user, the farmer, and you cannot do that. The court said you can use eminent domain. A city has the right to use eminent domain, but then you will have to compensate the farmer for the rights that you have, for the water you have taken. You cannot just take it. This case is still good law in New York. This case would prevent gas drilling companies from taking water away from the land that they have leased and pumping it elsewhere. It does prevent cities and municipalities from taking water away from the watersheds that they own. The existing law that we have on municipal permits is basically to set up a system for requiring permits when municipalities do use eminent domain to take water from other locations. They can do that, and the statute sets up the conditions upon which they can take water from other resources, from other sources. Now, one of the consequences of this legislation is that there's no distinction, if this legislation passes, between municipalities and other users, but municipalities will still have the right to use eminent domain. So the question is, if municipalities have the right to use eminent domain and then can sell their water and then use eminent domain to acquire more water, what are the limitations on eminent domain? What are the limitations on what they can take by eminent domain and then resell? So there are questions about usage. I just wanted to say that the New York law on groundwater is very different than the law of Texas. In Texas, there are unlimited rights to pump groundwater. No limitations. A series of court cases recently reaffirmed, if you harm the other users by your pumping, that's just too bad. So we have a rule in New York that is, it's actually the Four-Bell case established the American rule, which is that groundwater withdrawals have to be reasonable in the same way that surface water withdrawals have to be reasonable. An interesting case in Colorado recently, the Colorado Supreme Court held that with produced water from gas drilling is subject to the state's water laws. And this proposed legislation in New York does say any water withdrawal requires a permit. There is water in the formation in the Marcellus Shale. If water is being produced by the gas drilling companies, is that subject to the permitting requirements? The industry was very disturbed by the Colorado decision and sued, but I think they have dropped that lawsuit now. So the critiques of riparian rights is that it's too indefinite, and that if we're going to have markets for water, we need to have permits. So that is a pressure for this permitting system. I know several people went to a recent conference in White Plains about the wonderful water resources that we have in New York, how this is a wonderful opportunity for our state to benefit by selling water. Basically, permits are a form of prioritizing water. The permit holders will have priority rights over other users, and they serve to entrench the large users. So that's a big concern with this legislation. The only people who are entitled to have permits under this legislation are those who are using 100,000 gallons a day or more. All existing users are mandated to be given permits without regard to the use that they're putting it to or to the needs of other users. So I did want to ask Jack to say a few words about the concerns that the Coalition to Protect New York has with this legislation and the work that they're doing.
Hi, I'm Jack Haas, and I think several of you know me from last year in the same space here. Things have certainly changed. Seems like none of us have enough time to do what we need to do. Okay, a couple minutes. Major concerns on this water withdrawal bill are who's driving it, where the money came from to drive it. We've been informed by counsel to the Codes Committee in the Assembly, senior counsel there, that the chemical industry is behind this. We are wondering why the drilling folks have not come out publicly and chastised this bill if it in fact is not benefiting them. As far as we just recently learned yesterday, of course, you're all aware of this too, I'm sure that Assembly and the legislature's gone home until May 2nd. It's bought us some time to get more information out. We've got two statewide organizations pushing this bill, Environmental Advocates and CCE, Citizens Campaign for the Environment, as well as some national groups, NRDC. And we question the intent of their involvement around this bill, not to sever the environmental movement here, but we think that they're mistaken in pushing this through, getting it into a permitted regulatory environment and not ensuring that the riparian judicial relief system is carried over into the permitting process. So several of the points that Rachel has raised here are germane to that concern, that if we're going to move it into a permitted regulatory oversight, as several of you who fought in these environmental battles for a long time know that you go before an administrative law judge and you favorably can win those fights all the way up to the level of where the commissioner of DEC makes the final decision. He can override all of those administrative law judge decisions that you've accomplished in your fight against an environmental battle. So as Ben Price points out, you know, there's no democracy in a regulatory system. This is totally dependent upon a political appointee, the commissioner of DEC, that can override any of these hearings that are held within a permitting process. So our worry is, looking at who's pushing this or not pushing this bill and not being concerned about it, I think we need to draw some concern over it, and I urge you to read the bill. I think a lot of the environmental movement has not read this bill, does not know the total impact and the interconnections between this bill and other parts of the law. One of the big problems that we're having right now is that the Compact for the Great Lakes has sent a letter to all the elected officials in New York State pushing this. And it's being pushed because no other states have met their legal obligations under the Great Lakes Compact up to this point in time, and they're saying that New York should be the first state to do that. I think we need to step back and examine some of the players here, and I encourage all of you to read these bills. Thank you.
I'm going to address my comments now to two different things. First, powers that local governments do have with respect to gas drilling. And then I'm going to spend more time on what's called the takings threat. I think one of the reasons I feel that we are moving in a successful direction of banning this kind of gas drilling is that the people supporting gas drilling have, and the lawyers and various spokespeople have begun to make this threat that, well, if you ban gas drilling, then that is a taking of my property. And you can't do that. And remember, when a lawyer says you can't do that, you have to take that with a grain of salt. But we're hearing more and more about, even among some people who are supposedly in agreement with us, oh, well, you can't have a ban because then there's going to be all these lawsuits that we're taking property. So it's a sign of our success that those arguments are being made. There's a real possible banning of gas, and so they're rolling out the next argument. Okay, but so first, though, I do want to address the powers of local government, and let me say I've already done a presentation on this that's about an hour long, and I don't have that kind of time, and I think that some of the information about it has been disseminating out to the public, but you can actually watch a much more detailed presentation on this by me if you go to essentialdissent.com, or anyway, just Google Essential Dissent, and I made a presentation on January 27th this year in Norwich that is a lot more detailed. when I first started becoming aware of the potential problems of gas drilling, there was a sense, there was some trainings, particularly for like local municipal officials, which I was, from people in Colorado and Wyoming who said, well, you can't ban it, but try to get organized, get your ducks in order, try to get to negotiate some mitigations, do the best you can. And they sort of warned us of the problems and sort of had the more negotiating strategy, get mitigation, stuff like that. And of course, the municipal governments were told, well, there's nothing you can do. And the one thing that they allow us to do, supposedly, is there's in the Environmental Conservation Law, Section 2303- subsection 2, a provision that says the Department of Environmental Conservation shall regulate gas drilling, but local governments shall retain their powers to control over their roads. And then there's a little provision about taxes, which I'm not really going to cover today because there's not much we can do, there's not much going on in that area. So that was sort of the one little tidbit they held out to those of us in local government. Well, you do have the power to regulate your roads. In my little town of Afton, we eventually started looking into having a road protection law. We eventually did pass one by a vote of 3-2 after about 4 versions, with all kinds of arguments being brought out by anti-gassers, and we came up with responses. We amended, we tweaked, we tried to deal with the concerns, and yet really the purpose was not to ban or claim broader rights. It was just to claim a right that even the government acknowledged we had, which is to control our roads in a way that made sure that the taxpayers weren't paying for any destruction to our roads. It was also a way of educating our local people about the impacts, because literally some of the initial arguments were, oh, all those heavy trucks will actually compact the road and make them better. Okay? That was the level of consciousness. Eventually, enough people went down to Pennsylvania or read the papers, and so it was an educational process. And that has continued. And some of you who are real local may know there's all kinds of activities still. We did eventually pass a law. It was a kind of concentrated heavy traffic. We tried to stay within the kind of legal parameters that they allow us. And right now, we're in the position of having been informed, and I think under sort of legal precedent, that we needed to do an environmental assessment form and a determination before passing the law. And so we've had to kind of step back and are now in the process of trying to comply with that, crossing the T's and dotting the I's so that we can pass the law, but meanwhile, land coalition groups have started attending our meetings en masse, and in response to that, local people have started attending our town board meetings en masse. And so it's like there was a little bit of kindling that has started a more open flame of anger and intensity that is daunting, but in some ways very encouraging. People are beginning to understand how serious this is, and you all have been understanding that for a long time, but that's not always the case in our little towns, where a lot of people don't read the newspaper, or if they do, the newspaper accounts are biased, or they talk to the kind of established economic powers and interests in the town, who have either made or expect to make money from gas drilling. So I'm not going to really address much more than that. It's just a little baby step in claiming some rights that we should have over our own local community health and governance. There have been much more ambitious responses on the parts of some other local communities, such as over near Otsego Lake in the Cooperstown area, as well as in the town of Ulysses, for example, in Tompkins County, and in Sullivan County. I don't remember the towns, but Carol Roig, where? Highland, yes. In fact, actually, I guess there's 3 towns that to some extent are working together, but Highland in particular, where they've consulted with lawyers who have looked at this preemption language, and we don't call it Dillon's rule in New York. That must be a Pennsylvania term. But again, there was this environmental conservation law, this statute in New York, which says the DEC has sole authority to regulate gas drilling. I'm shortening it, of course. It's oil, gas, and solution mining. To regulate gas drilling, but towns still have authority over roads. Local roads. And so while supporters of this kind of gas drilling say, well, that preempts communities from engaging in zoning or any kind of a determination of the use of their land, lawyers have done the research and are being advocates for their clients, and at first there seemed to be, you had no rights, and then I think the earliest argument that no, we still have, even under current law, the right through zoning to regulate our land, not regulate gas drilling, but our land, came out of an article in the New York Zoning Law and Practice Report of January and February of last year. So just a little over a year ago. And it set out the argument that while local governments under this statute don't have the authority to regulate gas drilling, it doesn't take away their right to regulate through zoning laws their land use. That's what zoning generally does. And several people have crafted very good laws in New York State, in Ulysses and all that, and I would specifically point out that Helen and David Slotji at the Community Environmental Defense Council have worked very hard and crafted very good model laws and memos to support it, to show that, in fact, there is good legal precedent through similar interpretations of similar worded statutes, like the Mined Land Reclamation Law, in which the highest courts in the state of New York have said, well, yes, while a community can't regulate gas drilling, and by that you think of things of the quality of the concrete in the casing, or the width of the casing, or the actual regulation of the gas drilling, but that the courts go on to say they can. That doesn't mean that communities have had their right to control land use through zoning. That has not been taken away just because of that preemption language in the environmental conservation law. It's a fairly, it's a sophisticated, detailed argument. It helps to have a kind of a prior history of the community having, for example, a comprehensive plan in which the community says we value our rural community, and they communities that don't want high impact industry coming into their towns. And so when in situations where communities have done comprehensive plans or are now doing comprehensive plans that lay out their vision for the use of their community land, there are very strong arguments. Those cases haven't been litigated yet, but municipalities that are passing those laws, have certainly really strong arguments. And so that's how we then get into the, in fact, let me back up though a little bit and say, because Ben mentioned New York is a home rule state, and that is the case. It's said Article 9 of the New York Constitution, and basically it provides, it provides broad authority to enact laws, for local governments to enact laws on property, affairs, government, and for the protection of order, conduct, safety, health, and the well-being of persons and property. And this last section that I was quoting from it, for the protection, order, conduct, safety, health, and well-being of persons and property, is often referred to as the police power. And I wanted to make that clear because, most of us think of police as, well, they're the gals who can come and charge you with crimes and arrest you. But the term police power in sort of legal jargon has a much broader meaning, which is that governments, local governments, have the right to protect the safety, health, and welfare of the people and the property in their community. So that's arguably a very strong right. And in fact, the cases that have been brought forward and talked about in terms of supporting the idea of local communities being able to regulate land use, if not regulate gas drilling, that they be read as not conflicting with each other and being given broad and liberal interpretations because of the language in that home rule part of our Constitution as well as a local statute. Okay. Now, so there's a lot more detail, and the Slotchys in their with Community Environmental Defense Council have a lot more detailed arguments, and you can, and I at least refer to them in my presentation, and we will be actually putting on, I guess, a Google site certain documents after the conference, and I am in the process with some help of editing my oral presentation back in January into some sort of written document, and that'll go up on that Google site for people to look at if that's helpful. So now I want to switch to this takings argument. And as I mentioned earlier, I think that argument is being brought up more and more because it's a sign of our success. When they start talking about, well, if you win, we're going to sue you, is really a sign of making some progress with the public's opinions, and the sort of frame of what's acceptable to talk about is being expanded to include ban. I mean, I remember people saying, oh, you can't talk about a ban. And that's no longer the case. People are talking about a ban. So, but there's concern. Again, because lawyers will say, we're going to sue you, or people say their lawyers say, we're going to sue you, and there's a concern. Money's tight. So I want to explain what this whole takings argument is, and again, I'm not going to go through a lot of cases. That's going to get written up and put on that Google site too. But the basic argument is that the Fifth Amendment of the United States Constitution provides certain protections, and it's part of the Bill of Rights. And the Fifth Amendment lists a bunch of them. There's double jeopardy, the right to, you can't be forced to testify against yourself. And then it goes to, it says, and persons can't be deprived of life, liberty, or property without due process of law, and here's the key, nor shall private property be taken for public use without just compensation. I'll repeat that. Nor shall private property be taken for public use without just compensation. So the word taken in there is the takings that people refer to when they say the takings clause. You can't take private property, the government that is, can't take private property without giving just compensation. And that was, it was an important right, because the government before that did that, took it and didn't compensate. And generally that's been talked about as eminent domain, and that's there's historical evidence to suggest that the original intent of the takings clause was meant to just be the physical appropriation of land. So we're thinking eminent domain, we're taking this land because we're going to build a public school here, or we're going to build a public park, or we're going to build a road or something, a public use and a physical appropriation of land. Although it could also, in that context, include personal property. The government's going to take your horse or your mule or whatever. So that's what the takings clause used to refer to. But what if the government, say through a town zoning law or a state law banning gas drilling, without taking title to any property, where gas companies and gas lease holders are expecting to drill for gas? That is, what happens if you restrict the use of the land or the profit-making opportunity without actually physically taking the land? And there are cases, of course, talking about this. I hear, it's really I hear the concept from various people of, well, I can do anything I want with my property. I'm sure you have all heard people tell you that I ought to be able, I've heard people say the Constitution gives me a right to do anything I want with my property. And that's not really the case. The U.S. Supreme Court has said, as early as 1887, that all, and this is a quote, all property in this country is held under the implied obligation that the owner's use of it shall not be injurious to the community. 1887. And they actually haven't ever had the nerve to say it differently. Okay, so the Supreme Court has, and here I use the word, created a muddled area of law with regard to takings, because as you do the research, there are inconsistent decisions. For example, in 1922, the Supreme Court held that while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking. And that, interestingly enough, was a Pennsylvania case where the subsurface owners, coal mining companies, were digging out so much coal that the surface owners' land was subsiding. And yet, when Pennsylvania tried to protect themselves, the surface owner, the Supreme Court said, no, that's a taking. And yet, in 1987, an almost identical statute in Pennsylvania held the opposite. Luckily, sometimes it's good that the Supreme Court is willing to state a different principle. So the more recent principle is, said that was not a taking, which the government had to pay the owner of that subsurface right for. So you can see there's inconsistent decisions. And I won't go through lots of cases because there's limited time. One of the most major ones that did encourage the not just gas drilling people, but large corporations who were trying to resist, who wanted to take profit-making opportunities by exploiting land, is a case called Lucas versus South Carolina Coastal Council. And that, in that case, Justice Scalia, you can almost always tell a case by the outcome by who the judge is, remember my principle, said that a preventing of a particular profit-making opportunity would be a taking where it was a total taking. There had been a judicial finding that this guy's coastal land that he wanted to develop into a resort, the South Carolina had prohibited him from doing that, even though he had owned the land before. And so he said, well, you can do that, but you got to pay me my lost profit. and there had been a judicial lower court finding that, in fact, this prevention of the right to develop the land had rendered his property to be of zero value. Zero value. And in that particular circumstance, it's like a physical appropriation, the way eminent domain is, the taking of the land for the public school or whatever. And so Justice Scalia kind of carved out this exception of if it's for public benefit generally, you don't have the right to compensation, but if the taking is total, then you should get compensated. So, and then after that, there's cases that seem to go the other way. And to summarize, to make a takings argument, the following conditions have to apply. A taking claim by, pro-gas people cannot be based on an interest that the owner never had. And that, so when you, there's all kinds of statements throughout all of the takings cases that you can't, it's not a taking if what you're doing is trying to exploit your land and it's affecting other people. You never had the right, when you own property, to create a nuisance or a problem for your neighbor, okay? So you don't have a right to do that. You never had that as part of your property right. It's, that concept of all property is held under the implied obligation that the owner's use of it shall not be injurious to the community. That you don't have the property right to injure your neighbor's community. That's one. Number two, a taking claim does not apply if the property can be used for other purposes. So there was a judicial finding in this Lucas versus South Carolina case that it was worth zero. But if you can show that the property has any other value or purpose, and almost all of the cases find that there is still economic value, it's just that it hasn't been totally extinguished. It may be reduced in value, but the mere diminution of value of property, however serious, unless it's total, is insufficient to be a taking, okay? So, there's a gravel pit, there's a case. A gravel pit, the town of Hempstead does a regulation saying you can't dig gravel more than 2 feet above the water level. And the guy who's had the gravel pit since 1927 says, wait a minute, I can't do anything with that piece of land. He lost that case because he still owned the land, he can do other things with the land. He was not able to prove that his land had zero value. It had a lot less value, but it didn't have zero value. And third and final, the burden of proving that a government's law or regulation is unreasonable, that is, that it really couldn't accomplish the goal that it was setting out to claim. If you can prove that that's unreasonable, then you, the one who's claiming it's unreasonable, have to prove that, and in general, courts do give deference to the judgments of legislatures. Of course, that can vary from time to time. So, to end, in a case called Jernat Asphalt Products versus the Town of Sardinia, which is a New York Court of Appeals case regarding mineland reclamation, which is a similar statute to the environmental conservation law, the highest court in the state of New York said, a municipality is not obligated to permit the exploitation of any and all natural resources within a town as a permitted use, if limiting that use is a reasonable exercise of its police power, remember I told you what that was, to prevent damage to the rights of others and to promote the interests of the community as a whole. So we have the right to make these claims. We have good precedent to support the fact that these will not be considered takings, and that's just a lot of claiming on the part of the lawyers and the supporters of the financial interests that would like to discourage us from doing these things, but that doesn't mean they're going to win. Okay?
Well, I'm Mike Bernhard, and what I would like to talk about is how these regulatory systems that we can see don't work for us, how they came to be. It's a history lesson, and I'm just going to read from my, my script here. Following the Civil War, an explosion of economic activity based on steel, fueled by coal, sourced and traded globally by railroads required huge pools of finance capital. Finance capital favored and intensified the consolidation of industries, which we identify as the rise of the robber barons. This intensified and consolidated industrial system required a bottomless pit of laborers who had no bargaining power. And so we identify this age also as one of immigration, of tenements and sweatshops. Conflicts over wages and conditions led to pitched battles in coal fields, in steel plants, on railways, conflicts that were most often regulated by the U.S. Army. The intensified and consolidated industrial system also required and created a professional class, engineers and managers and accountants and teachers and lawyers, that was invested in the system through higher levels of incomes and assets, status and market power. This more secure class had consumption-based issues, tainted food, monopoly pricing of goods and services, limited access to new technologies such as telephones, electric power, and cheap transportation. Around the turn of the last century, these two threats to a smooth functioning of the industrial system, one at the point of production, another at the point of consumption, required and created what we're dealing with today, a system that regulates economic activity outside the democratic process, in that it removes economic issues from the will of the majorities, and insulates those industries from certain market consequences. High school versions of history that we were subject to leave us with the impression that the era of the robber barons and labor strife and Upton Sinclair's jungle somehow morphed into a progressive era. By this reading, the excesses of the former period were expunged by the application of Teddy Roosevelt's manly trust-busting and the establishment of a host of independent, politically neutral, professionally staffed agencies that would guarantee that there would be no rat feces in our hamburgers, that medicines would work as they were claimed, and that there would be no insider trading on Wall Street. The first leading example of these regulatory agencies was the Interstate Commerce Commission. Like all the independent regulatory commissions that followed it, independent in that it was a multi-headed, each commissioner having staggered, overlapping terms as distinct from later regulatory agencies that have a single head appointed by the president and residing within an executive branch cabinet office. The Interstate Commerce Commission was established to blunt the conflict that arose in the decades after the Civil War. Remember, between the railroads and the farmers that had to ship their stuff to market. Elevator rents, rate discrimination, monopoly pricing, and other causes of deadly agitation on the part of the farmers would be dealt with by what we would call today technocrats on the commission staff, who would be dispassionate, scientific, and politically neutral in setting rates and schedules and other conditions, rationalizing the operation of what were called natural monopolies. It doesn't really make sense to have 5 railroads coming into Afton, after all. The best of both worlds, economic power and advantages offered by monopolies, tempered by expert professionalism. A raft of regulatory commissions followed to deal with the abuses of concentrated capital, is the story. Monopolies. In food processing, pharmaceuticals, mining, securities trading, air transportation, communications, and so forth. Today, we in this movement are aware of the Federal Energy Regulatory Commission, and on the state level, the Bureau of Oil and Gas Regulation, the Public Service Commission, and various agencies that pretend to regulate these industries through permitting processes. 100 years after the first flush of these regulatory agencies. Anyone involved with them as activists, defending public airwaves, environmental health, transparent government, community economies, and any other aspect of public life at odds with the preferences of profit-seeking capital can and does assume that the agencies or agencies that regulate that field of activity is captured by the industry it purports to regulate. When did this capture begin? The answer is right from the start. The U.S. Attorney General that was in office not long after the ICC, Interstate Commerce Commission, was established, was asked if he could do something to get rid of the ICC. Quote, "The commission is or can be of great use to the railroads. It satisfies the popular clamor for government supervision of the railroads at the same time that supervision is almost entirely nominal. Further, the older such a commission gets, the more inclined it will be found to take the business and railroad view of things. The part of wisdom is not to destroy the commission, but to utilize it." For this particular commission, the enabling legislation assured inadequate enforcement powers, left railroad safety issues to this non-regulation of the states, left key issues like short haul and long haul fare discrimination to the commission's interpretation rather than it being in the statute, and excluded what it deemed to be non-economic issues of race discrimination in transportation, which of course lasted into my lifetime. The result is that the commission acted on the interests of railroad and trucking companies and set rates at an artificially high price at the same time, which at the same time excluded any competition through restrictive permitting. So the monopolies that nominally regulated by the ICC were actually protected from market forces that might have threatened their capacity to control prices, costs, and production from the boardroom, and protected from the power of communities to legislate control through the ballot box. The Federal Trade Commission, Federal Communication Commission, Security Exchange Commission, Consumer Product Safety Board, the Nuclear Regulatory Commission, the National Labor Relations Board, the FDA, the EPA, the FERC, any contact that any of us have had with this alphabet soup of regulatory agencies and commission has resulted in our learning that they serve the needs of the monopoly capital and serve to deny us meaningful control over our communal and sometimes personal lives. In the struggle in which we're joined, we see quite clearly that the agencies that nominally regulate the industry, which in fact exercises monopoly economic powers to set price and production levels, one, removes the decision-making from communities that host these activities, effectively allowing corporate boardrooms to determine the nature of our communities, and two, insulate those industries from market forces. Thus, the regulatory agencies confer on the corporations compulsory integration in gas drilling and gas storage, eminent domain in siting pipelines and power lines, and stay tuned for the siting of generating facilities. After the Deepwater Horizon, or BP, blowout in the Gulf of Mexico, the Minerals Management Service, which had the regulatory responsibility of offshore oil drilling, declared a moratorium on the issue of new deepwater drilling permits. The Cabinet Department in which the Minerals Management Service was birthed, the Department of the Interior, is headed by Ken Salazar, who as a senator had voted against the amendments to repeal tax breaks from ExxonMobil and other petroleum companies, and who in 2006 voted to end protections that limited offshore drilling on Florida's Gulf Coast. Barely 3 weeks after the disaster, he had issued 5 more permits, and in March 2011, the renamed MMS began to issue more drilling permits in the Gulf of Mexico. We need only to briefly mention recent activities of regulatory agents to remind ourselves of their role in maintaining monopoly powers in the marketplace and depriving us of economic democracy in our communities. We know the role of the FCC in turning the public airwaves over to monopoly broadcasters and quashing community radio. We know the pollution of genetically modified organisms in our environment was enabled by the flying wedge of the FDA, the EPA, and the USDA. We know how the New York Federal Reserve Bank, nominally regulating Wall Street during the recent real estate bubble engineered by banks and hedge funds, in turn engineer the purchase by the Fed of the credit default swaps that AIG had sold to Goldman Sachs, Merrill Lynch, and Deutsche Bank at 100 cents on the dollar. We know that the Nuclear Regulatory Agency, which has never refused a permit application, recently approved a 20-year extension for the Vermont Yankee plant, despite the overwhelming vote of the state legislature to deny the extension because of underfloor pipes known to be leaking radiation. With this knowledge being widely shared in its contours, if not in its particulars, how is it that people who are appalled by the prospect of gas drilling or high-volume hot fracking or waste injection or dilution and dumping or however they conceive, like the blind men and the elephant, of this corporate profit opportunity, think that any appeal to the regulatory process will save our skins? Thank you.
Ben Price again with the Legal Defense Fund. I'm going to be real brief. I know we're running behind time. Just wanted to say that regulatory structure of law is the consolation prize for the stripping of rights. It creates the illusion that we have a democratic process and that we can get the outcomes we need to protect ourselves and our families and our communities, when in fact it does the opposite. Regulatory law regulates us. It makes our strategy, our thinking, our organizing predictable. Environmental law isn't the only kind of regulatory law. Labor law is regulatory law. National Labor Relations Board is a regulatory agency. Why? Because the rights of workers aren't being recognized. The relationship of workers between the workers themselves and their corporate employers, that's what's being regulated. Their rights are not being recognized. We might say that under the 13th Amendment, they have a right. There was an abolition not only of slavery, but of involuntary servitude. Well, I guess if you're working under conditions you don't agree to, you might describe that as involuntary servitude. But the 13th Amendment is not where the courts or the legislature recognize the rights of workers. They don't recognize them at all. They recognize workers as a component of the economy. And so they're regulated. I'm going to say the most controversial thing I've said so far, and that is that there's never been an environmental movement in the United States. Why do I say that? Because movements advocate for the fundamental recognition of rights in law. That's what the women's movement was about until they settled just for the vote instead of equal rights. And I don't mean they settled. That's what they were cornered into. That's what we got out of the civil rights movement of the 60s. Most of the laws, most of the decisions that were adopted were couched within the Commerce Clause, not within the 14th Amendment's recognition of equal rights or equal protection of the law and due process of the law. The 14th Amendment was very clearly handed to corporations in 1886 in the Santa Clara case, and ever since then in reinforcing decisions. But the rights of people, not so clearly ensconced in the fundamental law of the land. And when I say that there has never been an environmental movement in the United States, it's because we've settled for regulating, mitigating harms, so-called best practices, which I would argue that best practices means banning fracking. That would be a great practice. Except for we're not allowed to actually protect the rights of our communities and of the ecosystem because they're not recognized to have those rights. And guess what? We haven't fought for them as such. And so shame on us. Imagine if the abolitionists had said, you know, slavery is really horrible. What we need is a slave protection agency. What if that's what they did? Well, that's what we're doing. And we have to come up with a better way of understanding what the problem is. The problem is the fundamental denial of rights. Nature, under U.S. law, is seen to have a legal status only as property. Gee, that's the status slaves had before the 13th Amendment. They couldn't have rights. They had no human and civil rights because they were simple property. But the property rights of the slaveholder, they were ensconced in the Constitution and the Fugitive Slave Clause of the Constitution. Well, we got rid of slavery, but we never got rid of the legal theory that says the right to own property is superior to human and civil rights. We haven't changed that yet. No wonder we get the outcomes we do, and no wonder we're told the best we can do is mitigate, slow down the rate of destruction, regulate, and end of the pipe laws that say if you can afford it, you can take the corporation to court and try and make them pay for the damage they did, but we can't fix the damage. Everybody knows you can't fix an aquifer. I'm going to end, I know we're way behind, but I would just hope that you will consider the possibility that we've been had, and we shouldn't settle for regulating when we should insist on rights.